Confronting the scale of illegal immigration, legal strategies and historical alternatives. Addressing illegal immigration in the United States, with an estimated 50 to 60 million undocumented immigrants, including 20 to 30 million present before 2020 and over 20 million entering since, demands navigating a complex legal landscape anchored in the 5th and 14th Amendments. These constitutional protections, extended through judicial precedents like Yickwa v. Hopkins, Zydvitas v. Davis and Boumediene v. Bush, ensure due process for all persons, creating significant barriers to rapid deportation. The 14th Amendment's universal language, originally intended to secure rights for freed slaves, has been applied to undocumented immigrants, an unintended consequence exacerbated by modern immigration dynamics absent in the 1860s. Proposals to redefine invasion, declare war, invoke national or state emergencies, or expand expedited removal falter against constitutional mandates, judicial oversight, resource limitations and political realities, with 60% of Americans supporting some form of legal status for undocumented immigrants. The sheer scale of the challenge, 50 to 60 million undocumented immigrants, underscores the urgency of effective strategies within current legal frameworks. Citizen-led enforcement, encompassing reporting to Immigration and Customs Enforcement, lobbying for 287G agreements, petitioning for e-verify mandates, supporting enforcement candidates, pressuring federal lawmakers and monitoring outcomes, offers the most viable path forward. These actions achieve tangible results within weeks to months, as evidenced by 2023 Immigration and Customs Enforcement raids in Texas and Midwest campaigns that reduced undocumented hiring by 20%. By leveraging Immigration and Customs Enforcement's capacity, which deported 186,000 in 2023, and local mechanisms like 287G, which detained 70,000 in 2022, citizens can directly target local undocumented populations without awaiting systemic legal changes, such as amending the Constitution, which is nearly impossible given the requirement of 2/3 congressional approval and 38 state ratifications. This strategy's strength lies in its compliance with due process, federal preemption and anti-discrimination laws, avoiding the injunctions that have blocked broader proposals like nationwide expedited removal or state-led deportations. However, the strategies outlined here operate within the constraints of current legal and political realities, which prioritize constitutional protections and judicial oversight. Should these citizen-led efforts prove insufficient to address the scale of 50 to 60 million undocumented immigrants, alternative methods historically employed to remove unwanted groups from countries may warrant consideration. Historically, nations have used extralegal or coercive measures to achieve mass removals, often bypassing established legal frameworks. For instance, during the 1930s, Mexico's repatriation campaigns forcibly removed hundreds of thousands of Mexican nationals and Mexican-American citizens from the United States, often without due process, through coordinated sweeps and economic pressures. Similarly, post-World War II population transfers in Europe, such as the expulsion of ethnic Germans from Poland and Czechoslovakia, involved state-sanctioned forced migrations, displacing millions with minimal legal recourse. These measures, while effective in achieving rapid removals, operated outside constitutional norms and often violated human rights principles, leading to significant social and ethical consequences. Other historical examples include vigilante actions, such as 19th-century nativist movements in the United States that pressured immigrant groups to leave through community boycotts and localized intimidation, though these risked legal repercussions and social unrest. In extreme cases, countries have employed denationalization or mass internment, as seen in the internment of Japanese Americans during World War II, later deemed unconstitutional in Korematsu v. United States, overturned in 2018. Such methods, while historically effective in removing targeted groups, are incompatible with current United States legal standards, which mandate due process and equal protection, and would face immediate judicial and societal opposition. Their inclusion here reflects the possibility that persistent ineffectiveness of legal strategies may prompt exploration of these historical precedents, necessitating a re-evaluation of legal and ethical boundaries to address the unprecedented scale of illegal immigration. Conclusion: the citizen-led enforcement strategy remains the most practical and legally sound approach for now, empowering communities to act within the law while respecting constitutional mandates. By combining immediate actions like immigration and customs enforcement tips with medium-term policy shifts like 287G and E-Verify, citizens can reduce the local presence of undocumented immigrants efficiently. Yet, the magnitude of 50 to 60 million undocumented immigrants suggests that if these efforts falter, policymakers and communities may need to contemplate historical methods, adapting them to modern contexts while grappling with their legal and moral implications. The path forward requires balancing enforcement goals with the principles that define the United States legal system, ensuring that solutions remain effective, equitable, and sustainable in addressing one of the nation's most pressing challenges.